Here's a CPA's guide to helping a client with an SBA PPP loan forgiveness denial. If you have such a client, you're going to want to help them reconcile the records. Now, although CPAs are prohibited from representing clients and filing an appeal with OHA, the administrative court, on these SBA forgiveness denials, the CPA is absolutely vital. And in all the cases we have, and we have quite a few with OHA, we always include the CPA because the CPA has a knowledge of how the company works. They know where the records are. They can help reconcile everything. And you want to have, perfect information when you're including that and submitting it to OHA as part of the appeal. So here are 3 things you can do to help your client prepare for the appeal, whether they do it themselves, because a business owner can represent themselves, or whether they hire an attorney. Number 1, you want to reconcile the payroll records, and you want to reconcile the gross wages that are reported on the payroll returns versus the federal income tax returns where the wages and taxes are reported, as well as the W-2s and W-3s, make sure those match, and then looking at the payroll journal. Because in some circumstances, we found that those numbers do not match, whether there was an amended quarterly payroll return that was filed that was not reflected on the general ledger and so forth, and it carried through onto the income tax return. So definitely want to make sure all of those match. Number 2, you want to exclude any wages over $100,000. So these are only going to be wages of $100,000 or less. So here's the formula. The payroll costs, which are used to calculate the PPP loan, would be gross wages, right? Plus the state unemployment insurance tax for California, the SUI, only the state, not the federal portion of any other payroll taxes, as well as any employee benefits. This would be health insurance, 401k contributions, sometimes in some cases uniforms if it was required and the employees did not pay for that uniform. That's basically the formula, and that's the yearly amount. You want to then take the average, right? If we're looking at 2019 payroll costs, you want to then take the average of that per month, divided by 12, multiply by 2.5, and that's generally the allowable, the maximum eligible loan amount for the PPP-1 loan. Now, under certain circumstances for the hospitality industry, you can multiply that by 3.5, and that is per SBA regulations. Okay, the last thing that you want to do is that you want to make sure that the right party is reporting the wages. Under certain circumstances, a company might have used a PEO, which is perfectly fine. You're just going to have to include information that confirms that there was a PEO involved, because those wages would not be reported under the company's EIN. It would be under the payroll company or the PEO's EIN. However, under certain circumstances, like for hospitality, you might have a hotel owner who hired a management company, and the management company reported the wages under their EIN, and that becomes a little bit more complicated. And this is where a tax attorney becomes even more useful, because we got to look at the hotel management agreement and determine whose employees were they. Certain circumstances, the management company says, well, they're going to be our employees and we'll take the responsibility. And they don't become the hotel owner's employees. And if SBA sees that, or if that is the state of the facts, then there might be a denial of the PPP loan forgiveness, and the client might have to repay the full amount back. The case that we had with SBA in exactly that scenario, there was some discrepancy, and we did some legal research, and SBA does rely upon IRS rules and regulation, and we determined that there was a co-employer relationship, right? So it wasn't just a management company, it was also the hotel owner, both of them managing. So this is something that has to be explored and legally presented in an appeal to SBA. One other thing, if you have a PPP-2 loan, you have to make sure, number one, that they applied for and received a PPP-1 loan to qualify, but they also have to have a reduction in gross income in 2020, either in a specific quarter, whether it's quarter 3 that matches up between 2020 and 2019, or the year-end amount has to be 25% or greater reduction in income. Lastly, and a very important issue, is the affiliation rules. If you have any company has multiple owners or some investors involved, get a total count for the employees, and that's in and of itself is a mathematical calculation, right? The full-time equivalents under the SBA rules. But also, if you have any investors or shareholders of companies or partners who owned other businesses, those other businesses and those employees could be lumped in together. And remember that you have to have 500 or fewer than 500 employees total to qualify for the PPP loan. So you're going to have to go into the affiliation rules, or an attorney really should do that, and understand whether there's any control from that one common investor or the shareholder who's a shareholder on the borrower company with the SBA loan and the other companies that person might own. Just making sure that they don't have control, that they don't have a majority interest. And there's a couple different tests, but it's very broad. So you want to make sure you're providing the right information in the appeal, and that's going off to OCA as well as SBA and OHA, making sure that we justify that there's less than 500 employees. I'm John Milikowski, founder of Milikowski Tax Law. I hope this information was useful.